Hello, everyone, and thank you for joining us for the SLW Institute webinar. The European Unitary Patent and Unified Patent Court. What are they? When are they happening? And how should I prepare? Recording of this webinar and the slides will be made available to all registrants. Feel free to enter your questions using the Q&A feature in the Zoom menu. This webinar will be presented by guest speakers Tom Hamer and Emily Collins. Tom is a UK and European patent attorney based in the San Francisco office of European law firm Kilburn and Strode. He advises US companies on navigating the European patent system. Tom regularly talks in the Bay Area and beyond, advising companies on how to patent borderline technology in Europe, how to make reliable filing decisions guided by the latest EPO case law, and how to draft patent applications to optimize their chances of success in Europe. Emily is also a UK and European patent attorney at Kilburn and Strode and is also based in San Francisco. Emily has extensive knowledge of navigating the European patent system for US applicants, and with a background in physics, helps tech companies obtain international protection aligned with a US strategy. Emily also speaks regularly on gender equality in innovation and mental health in IP. And with that, I'll turn things over to our speakers, Tom and Emily.
Oh, thank you very much, Paul. It's a pleasure to be here. Thank you for attending the webinar, everyone. Welcome to the presentation on the European Unitary Patent and Unified Patent Court. So we're going to be covering lots of things. Emily, did you want to say anything before we begin?
Just great to be here. Thanks to Shregman for having us. Yeah, if you have questions throughout, please do just type them into the chat box and we'll try and field them either as we're talking or at the end. We want it to be kind of more of a chatty discussion rather than kind of us just presenting. So please do kind of get involved and ask questions if you have them.
Cool. Yeah, Jeff, Paul, if you have questions, jump in. We're all friends here. Great stuff. Okay, let's get started. So let's address a potential elephant in the room for people listening. Why should you care about this? Why are we telling you this? And why are you telling me this now? So some of you will have had Europeans telling you for 10 plus years potentially that the UPC is happening soon, it's happening now, you need to prepare, the UPC is happening. Please do believe us this time, it really is happening. So the UP system and the UPC are really happening, possibly as early as October. So the provisional application phase has already begun. That happened at the start of this year. That was begun on the 19th of January. All the necessary countries have validated and ratified. Germany have a final formal step to ratification left. And so basically it's now in Germany's control as to when to trigger this 3-month countdown to the start of the UP and the UPC. Some people are saying this might be as early as 1st of July, which would mean that the UPC might open its doors as early as the 1st of October 2022. So what's happening now during the provisional application phase? Well, the UPC Preparatory Committee are doing things like building the infrastructure of the new court system. So they're doing things like building the IT systems, hiring staff, recruiting judges, doing all that stuff. But I think the headline is, it really is happening this time.
Thanks, Tom. So now we know that it's happening and why we're all here. Today, we're going to go through the background of the UPC, pros and cons of whether applicants will want to have unitary patents, the separate question of whether or not applicants will want to opt out of the jurisdiction of the Unified Patent Court. Finally, we'll look at what should we be doing now to prepare. So what should we as applicants or practitioners be doing now?
Great. Okay, so before we get into details on the UP and the UPC, and we talk about what is changing, let's take a step back and talk about the current system and make clear what's not changing, okay? So the European Patent Convention, and there's a potted history of the European Patent Convention there on this slide. It's not super important that we get into the details, but the European Patent Convention is the law that governs prosecution at the European Patent Office, the EPO. So this is not changing. So as I said, it's not necessary that we look at these details, but I always think it's interesting to note that the EPC, or at least the original version of the EPC, was signed in 1973, so significantly predates the EU. So the EPC, much like the European Patent Office, is not an EU thing. It's not connected to the EU. And that's, by the way, that's one of the reasons why Brexit hasn't massively impacted patent filing strategies in any real way. And that's why Emily and I can still act at the European Patent Office, given that we're British. So these are the countries in which, as an applicant at the EPO, the European Patent Office, you can seek protection. So the red countries are contracting states, the European Patent Convention. The blue countries are those extension states in which you can extend protection using certain formalities of the European Patent Office. Just to hammer home the point that this is not currently an EU thing, the green countries are those countries which are members of the European Patent Convention, so you can seek protection there by filing patents at the European Patent Office, but they're not members of the EU. Cool. So I think some, if not all of you, will know this already, but this is the current system. So the European Patent Office is a central body that oversees examination and opposition of the European patents. As an applicant, once you get your granted European patent, you must select in which countries you want that patent to be validated. You basically get a big checklist, and you can say, I want my European patent to come into force in the UK, in France, in Germany, in the Netherlands, etc., etc. And the result of that validation process is a bundle of individual separate national patents, as it says there on the slide, a bundle of national patents. But one of the, I guess, drawbacks or one of the complexities of the system is that every patent office in Europe has different validation requirements. Some require translations, some don't. Some require translations of the full claims or perhaps the full document. There are different fees to be paid, different deadlines to be aware of, and separate renewal fees of differing amounts that need to be paid to each individual patent office to keep your individual patents in force. And then if you want to enforce your patents in Europe, well, you've got to use the individual court systems of each individual European country. And the result of all this is basically a reasonably complex and expensive validation process and a reasonably complex and expensive litigation landscape. So this is a snapshot from a talk I gave around 5 years ago now. Again, the details aren't important. This is a snapshot of the current landscape for litigation in Europe. As you can see, we've got various countries in each row, and each court system has its own quirks and foibles and features. So if you're attempting to navigate this landscape at the moment, it's reasonably complex. And the court systems differ in things like discovery, whether there's interim relief, whether the degree of damages you can expect to recover, and things like timelines and things. And so it really takes an expert to navigate this system. It's reasonably complex. So what's changing at a high level? Well, if this is the current system where you get your granted European patent and through the validation process, you get a bundle of national patents. The change is that with entry into force of the UPC, applicants can now select a unitary patent, which will provide them with a single unitary patent that covers all of the participating countries of the EU. So the unitary patent is an EU thing. So this new system, it's not replacing the existing system. It will sit alongside the existing system so that applicants can request a unitary patent and also validate in extra countries using the current system. So as Emily's going to say, for example, the UK is not covered by the unitary patent, so applicants can, for example, obtain a unitary patent and then also validate in the UK to extend their protection, or applicants can just continue to use the existing system and not obtain any unitary patents at all. So it's essentially an additional option for applicants, and we'll talk later about whether we think you guys should or shouldn't be obtaining unitary patents.
Thanks, Tom. So the unitary patent, as Tom referred, is a single patent which will cover most of the EU. So I say most of the EU, it's shown on this map. So once the agreement has been ratified and comes into place, we expect that all EU countries to have ratified the agreement aside from 3, and those 3 are Spain, Poland and Croatia. At the moment, they're not planning to take part, but it might change in the coming years as they get around to signing the agreement or if they change their minds. So it's essentially a single patent covering most of the EU. At that grant stage, instead of splitting your application into a bundle of lots of different little granted patents, you can choose a single patent. All post-grant admin will be handled by the EPO, making it procedurally more efficient than going to your individual patent offices. There will also now be a new court called the Unified Patent Court, UPC. We'll come on to that later. I've just seen a question come up, what about Ireland? So Ireland is included in the unitary patent, It's currently not blue on that map because they haven't actually yet ratified, but they've done everything else. So probably just in the coming months, they just haven't done it yet, but everything's ready for it to come into place. So pretty soon they will ratify. That's the plan anyway. So apart from this kind of few months at the start where things are still getting into place, it won't be in it, but pretty soon it will be. And there are a few other countries like that, which eventually will be coloured in blue. That's just kind of a current status map. So there's also this Unified Patent Court, which we'll be talking about later, and that will see central revocation and enforcement of unitary patents. It will have exclusive jurisdiction over those unitary patents. So unitary patents can't be litigated at national courts at all. So it's worth noting, of course, that the unitary patent only covers EU countries and only covers those ones that have signed up. As Tom said, the existing system won't go away. That's not changing. This new system sits alongside it. So if you want to get protection in Spain, Croatia, or Poland, which haven't signed up, or in EPO countries which aren't part of the EU, including the UK and Switzerland, then you validate those separately. So even if you get a unitary patent, you might also want to do additional validations. There's also, of course, the option of not getting a unitary patent at all. So you could say, well, I only want the UK, France, and Germany. I'll stick with those. You don't have to use this new system. Next slide, please, Tom. Over to you.
Thanks very much. So I might be biased, but I think this is the most important slide in the presentation. Should applicants obtain unitary patents? So we're going to talk about some pros, we're going to talk about some cons. So I guess this is the sort of thing that you need to know if you're in-house. Should your company be filing unitary patents? If you're in private practice, how should you be advising your clients on this? Well, I guess an obvious benefit right off the bat. This is a single patent right. It covers a large number of countries. So unitary patents do give you the option of covering a large geographical and economical area for a smaller cost than would be possible using the current system. And because it's a single patent right, the validation process and all the admin, the renewal fee payments and stuff, it's much simplified. It's a lot simpler from admin perspective than the current system. On to the second bullet point here, patent infringement is determined by the UPC, not separate national courts. So that means that as a patentee, you can potentially get an injunction centrally at the Unified Patent Court, which applies across most of Europe. So this is quite a powerful tool potentially for patentees. And it does contrast with the current system where, if there's an infringer active across Europe, you would potentially need to use a court system of multiple different individual countries. So you need to use the court system in Germany and in France and in Italy, et cetera, et cetera. So you could get a centralized injunction that applies across most of the EU. So that could be quite a powerful tool. As for the translation requirements, there's going to be a reduced translation requirement, at least reduced for lots of people. So if you're an applicant that's currently validating using the current system in lots of countries in Europe, you'll know that lots of different countries require translation. So the claims might be the claims, might be the full document. However, with a unitary patent, you only need to file one translation of the entire patent. So if you're prosecuting in English, you can choose which EU language you want to file your translation in. And by the way, this is only going to be for a transitional period that is expected to be for 7 years. After that, the UPC preparatory committee think that machine learning algorithms will have come on so much, machine translation will have reached a quality that no translations are required whatsoever. And in fact, they're going to use I find this quite interesting because this is the space that I work in. They're going to use the translations that applicants file as training data for these algorithms, which is quite cool. So reduced translation requirements potentially, again, is simpler, isn't it? We've got renewal fees. We tentatively put renewal fees in the benefits in the pros column. So it's definitely an advantage that there's only a single renewal fee due to keep a unitary patent in force. So again, from administratively, that's simpler than the current system of paying different renewal fees to different patent offices. The cost of renewal fees for a unitary patent are basically roughly based on this idea that people tend to, or an average number of validation countries is around 4 or 5. So the cost of renewal fees for Unitary Patent are roughly equivalent to the combined costs of around 5 individual member state renewal fees. So what that means is that if you're an applicant currently validating in 10, 11, 12, or a huge number of EPC states, this will definitely represent a cost saving if you file a Unitary Patent in terms of renewal fees. On the flip side, if you are currently only validating in 2 or 3 validation countries, for example, just the UK, just France, just Germany, just Italy, this will probably be would not represent a cost saving.
Tom, we have a question in the Q&A, and that's for the required translations on this transitional period. Is that the entire application or just the claims?
It's the entire application.
Great.
It's the entire application, yeah. And that translation, by the way, it's not going to have any legal effect. It's going to be for information purposes only. And so some people are kind of speculating currently to what degree does it really need to be accurate. But I guess that's sort of the thing to talk about.
And that's one of the reasons why there's, like, for the transitional period, there's quite a high chance that for some people the translation requirements might go up for getting a Unitary Patent rather than down, which is like the overall aim is for them to go down. But if currently you're just validating in London agreement countries, you know, where you only need to do a translation of the claim, now having to translate the whole patent is, for this temporary period, possibly going to be an increase in translation requirements.
Yeah.
We have some other questions. I just want to let everyone know that I think that these questions will be addressed in future slides. So we're just going to hold off on these questions now, but I see them and we'll make sure to get those answered.
Cool. So on to some downsides. So I guess the flip side of being able to obtain this central injunction as a patentee at the UPC is the risk of central revocation in the UPC. So suddenly, there's a court that exists in Europe which can wipe out your patent protection across all of Europe. So this could potentially be quite a big risk, especially if there's, you know, a very valuable patent, very valuable patent family. It's certainly something to bear in mind. I guess this is the flip side of being able to obtain centralized infringement and enforcement decisions, the risk of central revocation. The second point there, higher cost of renewal fees. So if you're someone who is, or if you're a company that's interested in the cost saving that potentially could be represented by filing a Unitary Patent, make sure you do your math correctly, because basically the renewal fees for Unitary Patent go up quite significantly after 10 years. So if you're a company that's going to be keeping your patents in force for the full term, this is going to be very relevant. So make sure you basically do your maths correctly, and obviously we can help you with that. The third bullet point here, the territorial scope of a Unitary Patent cannot be amended or reduced in later years. And what do we mean by that? Well, some very patent savvy companies currently intelligently prune their European portfolio. So they might decide that they want to save costs. They're looking at a patent family it's currently validated in, for example, Germany, France, Italy, Spain, the UK. And they say, you know what, we will kill all of our validations, except we'll maintain the one in Germany. So doing that, you save costs, but you maintain some degree of protection in Europe and potentially a big market. So this intelligent pruning in Europe won't exist anymore. You won't be able to do that. With a Unitary Patent, it's all or nothing. And then finally, this is potentially the most important point, or the biggest downside, I think personally. There's going to be a blank slate on case law. So if you decide to obtain Unitary Patents, you're going to be opting into a new court system, which is untested and unpredictable. So Emily's going to talk more about the UPC in a second. But what I can say now is that we don't know to what extent EPO case law is going to be followed, or it's going to be persuasive. We don't know to what extent national law is going to be followed, or it's going to be persuasive. They haven't hired any judges yet, so we don't know who the judges are going to be. In other words, the UPC is potentially this big question mark. And I've talked to lots of my clients, and they don't want their patents entering into this jurisdiction of a court system which is so unpredictable and so untried. And I think it's also worth saying that you're currently granted EP patents using the current system. Your individual French patents, your individual German patents, for example, they will also fall under the jurisdiction of this new court unless you take an active step to opt out. And Emily will talk more about that in a second.
Great, thanks, Tom. So if after kind of hearing all those pros and cons from Tom, you're thinking that you or your clients might want to make use of this and actually get some unitary patents based off pending applications. What is that process going to be? So when the new system comes in, which, as Tom said, could be from October, but might be a few months later, once it's in force, you will have 1 month from the date of grant of the patent to request unitary effect. 1 month isn't that long, but as you know, in Europe, you get a few months lead up time knowing that it's going to grant because you get your intention to grant communication. That's what you'll have to do from October, possibly December, depending on when it comes in. If you have applications that are maybe about to grant and you're thinking, oh, but I want unitary effect on those, how do I do that? Obviously, that isn't possible in theory before the new system comes in because the system doesn't exist yet. But the EPO has introduced 2 new mechanisms to help applicants in exactly that situation. These new mechanisms will come in at the start of that sunrise period, which is 3 months before the start date. So if it's going to come in October, these will come in at the start of July, which is when Germany ratifies that 3-month countdown clock. The first of them, they're both listed there on the slide. They're pretty much what it says on the tin. So one is early request for unitary effect. If during this sunrise period, your patent grants and you know that you want to obtain unitary effect, you can tell the EPO that, and from the day it grants and when the first day of the new system, you will have a unitary patent. That's if you absolutely know that you want a unitary patent. You might not know that you want a unitary patent and you might be thinking, I want time to decide. If you can do that, you can request that your grant is delayed until after the new system comes in. So if your patent is due to grant during that 3-month period, you can request a delayed grant. Once the new system comes in, you'll get 1 month with which to decide whether you do or don't want a unitary patent. There's no obligation on you in that scenario to get a unitary patent. And note that you might have to use both of these systems in tandem if you want to use the first one doesn't necessarily delay the grant, so you might have to do both of these systems at the same time. There's also, so these will come in from that date that Germany triggers the thing, which triggers the start of the countdown, which might be July, but it might also be September. We're not quite sure. If you have a patent which might even grant before the start of this 3-month period, there are things that you can do to try and delay it, move that grant along just to get us into that 3-month period, so then you can make use of these EPO mechanisms. We'd recommend doing that by informal means, so you could use the further processing mechanism, which gets you a 2-month extension basically for a fee. You could also reject the text for grant, which will get you even longer, where you make a change to the granted text, and that will trigger another issuance of an intention to grant communication. So we recommend making use of those mechanisms.
So Emily, we have some questions piling up, and they're all sort of related to structure, an interaction between the unitary patent and the EPO or national stage one. So can you validate in a country that is covered by the unitary patent? If you choose unitary patent along with validation, and the UPC revokes the unitary patent, how does that affect the national ones? And then also, can you even get, a unitary and a national patent? And then, are there any kind of interactions between those two? Is there anything that links those two? Something similar to the US style double patenting, or would filing a divisional to get similar coverage? Can you just sort of talk about how those rights might interact with others?
Yeah, sure. So when, Tom, if I say any of this wrong, please feel free to just correct me.
Sure thing.
But when you have an EPO application and it grants, you can say, I want a unitary patent on this, and you can get other validations. You can't then say, I want a unitary patent and I want a validation of a country which is part of the unitary patent agreement. So you can't say, I'm going to get a unitary patent and also I want a German national patent from the same application. That's not possible.
What I would say, just I'm aware that this has been recorded and someone might look at it and pick us up on this. That is exactly what we expect to happen, but there's nothing currently in the rules that says you can't do that, but everyone expects that the EPO will not let you obtain a unitary patent and then try and separately and individually validate that same patent in, for example, Germany, France, Italy, that I think the EPO will not allow that.
Yeah.
But there's nothing explicitly in the rules that we have seen yet which would say that. So I agree with you, Emily.
That is what we kind of expect to happen, mostly based on kind of logical principles. But yeah, it's not, the rules yet there haven't yet been written. However, in theory, you still could have a national patent and a unitary patent in the same country. For example, if instead of going via the EPO, you go directly and file a German national patent in addition to filing your EPO European patent. So say at the end of the PCT phase or at the end of the priority year, as well as entering the EPO to get a European patent application, you also file a German patent application, and both of those grant. And in theory, so your European patent grants as a unitary patent, and your German patent grants as a German patent. In theory, there you still have got the same patent twice. It in the same country. It's expected that basically we don't know what most countries are going to do about that yet. Although some people are saying that Germany might be okay with that if you have one unitary patent and one national patent. So you can do it if you go via the national office for some countries. We're not sure that it's all countries. If you go by the national office and by the EPO. So at the moment, if you did that, bear with me, sorry, it is quite complicated. At the moment, if you get a national German patent and separately you have your European patent and you validate it in Germany, the European one, there's no double patenting, so the European one, I think this is right for Germany, it's certainly right for the UK. The European one takes precedence, so you can't have the same patent twice, even if you got there via different routes. For some countries, that'll stay the same, but for some countries, people are thinking probably Germany, you might be allowed both of them because this one is going to be in a different court to this one. This one will be in the national court, this will be in the unitary court. So it is quite complicated and nothing's set yet, but that's probably what's going to happen.
What I would say, Jeff, and just pick up on something that I think you mentioned in that, I think you said 3 or 4 questions at the start, but we had a really interesting chat, didn't we, in our prep, one of our prep calls for this, about double patenting and being able to file divisionals and this kind of thing. So the European Patent Office's approach to double patenting is that you can't have identical claims. So if you have a parent case and you file a divisional, provided the claims of the parent and the divisional aren't identical and don't claim identical subject matter, then there's no double patenting issue as determined at the European Patent Office. So what some companies do now is file, for example, using current EPO divisional practice, get a granted claim to the parent, make some change, file a divisional, make some change, file a divisional, and build up these so-called patent thickets, which arguably are all for very similar inventions or a similar product. One thing you could do or one thing that we were talking about doing with the unitary patent is kind of doing the same thing. So having a parent with certain claims, and you obtain a unitary patent for those claims, and then filing a divisional at the European Patent Office for similar claims, but not identical, and then validating the claims of that divisional separately using the current validation system in Germany, France, the UK. So then that would end up with a similar result of a unitary patent for a particular invention and a separately validated, very, very similar patent, but as a bundle of national patents using the current system. And there's nothing to stop that that we're aware of. So there are all these tricks that people are talking about.
Can you go both ways with that? So could you file using an existing EPO patent, could you file a divisional and go into the UPC?
Yes, providing that when you say a patent, because you can file a divisional at the EPO if you have a pending application.
Right.
So providing it's a pending application, you can file a divisional and then delay that divisional hugely until the new UP system comes in, using the mechanisms that are on screen here, for example, and then enter that into the unitary, obtain a unitary patent from that divisional, and then validate as usual using the parent. Yeah, you can do the other way around. Yeah. Cool. Emily, should we talk about the Unified Patent Court?
Yeah, cool. Let's
Thanks,
do
Jeff.
it. Next slide then, please, Dom. Okay, so we've heard about the first of these two new massive systems that are coming in. That was the Unitary Patent. The second is the Unified Patent Court, the UPC. As we've mentioned, the UPC is a single patent court set up alongside the Unitary Patent. It is a single patent court covering 24 countries. That's its like tagline on its website. So it has exclusive jurisdiction over unitary patents, with the pros and cons that Tom mentioned before, harmonising the effect of patents across Europe and potential to be cheaper. However, there is an important point which I think might get overlooked. As well as having exclusive jurisdiction over unitary patents, it will also have jurisdiction over granted traditional European patents in EU member states which have participated. So that is, even patents granted long before the new system comes into effect, say 5 years ago, those will still fall under the jurisdiction of this brand new court. Now, there are a number of reasons why applicants might not want their existing patents or future traditional European patents to come under the jurisdiction of a new court. As Tom mentioned, it's an unknown and there's no case law. Also, there's a risk of central revocation. So imagine, I'm just saying 5 years ago, 10 years ago, last year, you had an important family and you got 4 national validations, Germany, France, Italy, and say the UK. If this proceeding is brought at the UPC, one single decision could have all of the member state ones, so your French, your German, and your Italian patents, they could all be revoked in one quick decision. That's obviously a risk. So you might not want your patents to be opted into the system. And therefore, the EPO have made the system of being able to opt out traditional patents. And we'll come on to that shortly after we've gone over the rest of the details of the court. Next slide, please, Tom. So there's a little kind of organizational chart from the EPO, which is on the right-hand side of this slide. So you've got different divisions. You've got local divisions and regional divisions and central divisions, and they're the first instant ones. You've then got this Court of Appeal, which is going to be based in Luxembourg. And there's different rules for where new proceedings will be held. So infringement will be held at the local or regional divisions, and local or regional just refers to basically kind of the closest patent office for those situations. So they'll just have physical locations in Europe, and you will choose the local or the regional division based on either where the infringement occurs or where the defendant is resident or has place of business. So they're kind of geographical considerations of where the different acts or people are based. Infringement will be held at the central division, which is if the defendant is domiciled outside of the EU or if there's no suitable local regional division. So local and regional divisions have been set up in or for most countries, but some countries just don't have the funds or the inclination to have their own local one, in which case proceedings will go to these central divisions. Revocation in general is going to be held at the central divisions. So that's revocation and declaration of non-infringement. However, if revocation is raised as a counterclaim to an existing infringement proceedings, then it may be held at the court that the infringement proceedings are being held at, or that court can refer the decision to the central division. It's worth noting that in all of these proceedings, kind of when they're deciding whether or not a patent should be revoked, whether it's valid, the law that's being applied, the kind of assessment of whether or not something is patentable, that's the same law. That is going to be the EPC law, the law, the European Patent Convention that the EPO currently uses. So the questions that they'll be deciding in these courts is similar to kind of the existing things we know about, so problem and solution approach for inventive step and that kind of thing. So the patentability requirements, in theory, don't change between the EPO and the UPC. Next slide, please, Tom. If you are interested in where physically these courts are going to be, there's a list up there. Italy, the Netherlands, France, there's going to be 4 in Germany, Belgium, Finland, Denmark, Austria, and Ireland. There's going to be more added to those. They're just the ones that have currently been added. There's one regional court, but there's going to be some more for Sweden, and that will cover kind of Sweden, Estonia, Latvia, and Lithuania. The central divisions, which is where the revocation proceedings are going to be held, and anything where the defendant isn't based in the EU, are also, they're divided up by technology. So you'll go to the central division, and depending on which technology the patent in question relates to, that will decide which branch of the central division the proceedings are held in. So there's going to be one in Munich, which will cover mechanical engineering patents. There was going to be one in London that was written into the original rules, but since the UK left the EU and left the UPC agreement, that is yet to be determined where that one's going to be. It might be Paris or it might be Milan. And that one is going to cover pharma and chemistry. And finally, the final central division is going to be in Paris, which will cover all other subject matter. It's worth noting that the EPO, so the EPO patent prosecution isn't going to change. The EPO is still going to exist as it exists now. You will still file applications. There's no way to file a unitary patent application. That's not a thing. The EPO handles all applications and prosecution will exist as normal. Interestingly, the opposition procedure, which is where after 9 months grant, 9 months after grant, you can oppose a patent to have it revoked, that is still going to exist. So you've still got 9 months for grant to oppose a patent to have it revoked. And that might even become more important for a couple of reasons. The main one is that if you get a patent revoked by the EPO during the opposition procedure, that will revoke all national patents. So that will include not only a unitary patent, but it will include a designation in the UK, it will include Switzerland, it will include Spain. So that's even more powerful than getting a UP revocation at the UPC, basically because it will cover all possible national patents resulting from that application. The other thing to note about opposition is it is a lot cheaper than the fees of the UPC for revocation. If you go kind of, wait a while and then you revoke a patent at the UPC, that will cost just in kind of the UPC official fees, €20,000. Whereas to file an opposition, that's €880. So it's a lot cheaper and has the opportunity to be a lot more powerful. So some people are saying there might be an increase in the number of oppositions being filed. Finally, just on the role of the EPO is going to be in administrative charge of the UP register and the UP renewal fees. Jeff, I've seen you pop up.
Yeah, I have a question. And there are a couple interesting questions that are maybe a little more detailed in the Q&A section. But I was wondering, first of all, whether you think that Germany or Paris or France or wherever the pharma and chemistry court ends up, whether they will use any of their existing case law and whether that will be maybe formally or informally, taking some of that and applying it to the new court.
Yeah, good question, Tom.
Yeah, happy to jump in. Yeah, so I think, so MF, I think you covered that to a degree on the slides in that, so that at the UPC, no matter the division, whether it's the local, central, regional, they should in theory be applying the same law. So the order of precedence of law will be EU law, which doesn't really say anything about patents, to be honest. Then you've got the UPC agreement. This is an order of precedence. Then you have the European Patent Convention, and then you have national law. One of the big topics of debate is to what degree is national law going to be persuasive or going to be relevant to the new UPC proceedings. I think a big factor on this is going to be who the judges will be. So if they hire loads of French judges, it's not that they will only serve in like the French local divisions, they will serve all over the place potentially. And I think the answer to your question is to what degree, for example, French law will be relevant in the French local division. It will really depend. But I suspect that if you have which is a lawyer's answer, I'm so sorry. But I suspect if you have a lot of French judges on a panel for a central division or a local division, that they will be importing their own ideas of what patentability should be, their own ideas of what features the court system should be, probably more so than, for example, if you had lots of German judges. So I think a lot of that will come down to the makeup of judging panels. Does that answer your question, Jeff? or the question, do you feel?
Yeah, it actually complicates it. I think there's another question in here about potential forum shopping ideas, and I think it sounds like you're saying it might even be judge shopping, which in the US, we're somewhat familiar with this kind of concept. But yeah, I guess is that what you were sort of
Forum
saying?
shopping could be a real nightmare, actually. Again, I mean, I'll if you don't mind, I'll take the first go at this. But so let's think about forum shopping. So at the moment, so if you take, for example, well, first of all, the UPC is going to be self-funding, and different local divisions are potentially going to be incentivized to keep cases there rather than batting them up to the central division for lots of reasons. And so it might be the case that over time, different local and regional divisions develop their own flavor of features. Some are quicker, some have like a reduced number of cases on their docket, so you can expect things to move quicker, or whatever it might be. There might be some different flavors, and forum shopping will happen by virtue of that. So there'll be a whole argument about whether, where the infringing act took place, where people are domiciled, etc., etc. But what you've got to remember is that for traditional European patents, so not unitary patents, which have been opted into the system, there'll be a whole different branch of forum shopping. So in that case, you'll be deciding, do I want to use the UPC, or do I want to use the original traditional European landscape? So do I want to take this to a French national court? Do I want to take this to the UPC? If the UPC, which division? So it's going to be potentially incredibly complicated. And another area that people are suggesting there's going to be a big area for argumentation is even for traditional European patents, if they have been opted out, so are not part of the UPC system, or shouldn't fall under the UPC jurisdiction, there were these big arguments on whether the opt-out was formally correct, whether they were able to opt out, whether the person opting out really had the authority to opt out, if they were the exclusive licensee, did they have the authority of the patent owner, and blah, blah, blah. So, which will affect which forums actions could be brought if the opt-out wasn't formally correct. So I think forum shopping is going to be a big deal. I think it's going to be a nightmare. In fact, I think it's being incredibly complicated. And the whole idea of this system is that it was supposed to simplify things, but it might actually make things more complicated.
Yeah, there's also, you can also kind of do tricksy things. We haven't really talked about opting out fully yet, but to either try to kind of pin so if you opt out, if you don't get round to opting out, then, and someone brings revocation proceedings at the UPC, then there's no chance to opt out. So if you they could catch you off guard before you've got round to it, and catch with the UPC, and then you're stuck in the UPC and you're at risk of having your patent entirely revoked. If it could happen the other way round, so you opted your application out, but you suddenly realize that actually there's someone who's infringing in lots of different states. So you think, maybe I want to withdraw the opt-out, which is an option, and go to the Unitary Patent Court and Unified Patent Court and get a European-wide injunction. That sounds great and is a really good thing. But if before you manage to withdraw that opt-out, someone brings national revocation proceedings against one of your patents purely to stop you from doing exactly what you're trying to do, you then can't withdraw your opt-out and you're pinned to that national court. So there's lots of kind of different games to play regarding litigation and enforcement, and it's going to be really interesting to see how it goes. I think the best thing that everyone can do is just stay constantly aware of it, and if you think you maybe need to go to a certain court, do that as soon as you possibly can before you get pinned where you don't want to be pinned.
Yeah. So sorry, go on, Jeff.
One more question before before we move on to a new topic, is just a quick technical question for Emily here is, what is the scope of countries in the unitary patent? If later countries join, will they be bound to previously granted unitary patents? Good
question. No, so the unitary patent is only only takes force for the countries that have joined at the date your patent grants. So the starting ones will be valid in just the starting countries, and if, say, in a year's time Croatia joins, they won't then extend their protection to Croatia. Croatia will only have patents which grant from after the date that Croatia joined the agreement.
Thanks.
Cool. No worries. Well, it's a good segue, I think. Next slide, please, Tom, so we can go to talking about opting out. So we actually probably covered the main points on this, but you can opt out of, if you're existing, so you obviously can't opt out a unitary patent, that is part of the system. But your normal patents, your normal European validations in Germany, France, Italy, all of these existing countries, you can choose to opt them out of the UPC jurisdiction. This removes them from the jurisdiction of the UPC entirely for their lifetime, but you can withdraw the opt-out. You can't withdraw an opt-out and then re-opt out, though. You only get one shot. We can start doing it at the start of this sunrise period, which is that 3-month period leading up to the UPC, which we talked about before, until the end of the transitional period, which is going to be at least 7 years long, might be 14. After that transitional period, though, you won't be able to opt them out. So if you're thinking, oh, actually, this all sounds like a bit of a nightmare, I'm going to steer clear of the UPC entirely, you can't do that. It's coming for us whether we like it or not, because you won't be able to opt out forever. Opting out can't be done, as I mentioned when talking to Jeff just now, can't be done if an action has already been brought at the UPC. So if you're thinking, oh, the UPC sounds a bit scary, I don't think I like it, but you don't get round to opting out for another year, someone might bring a UPC action against you, in which case it's too late. So if you think you want to opt out, do that as soon as possible to minimize the risk of this happening. There's also a practical point here in that all owners have to agree on the opt-out, and it's best to ensure all licensees and owners agree. The reason I'm saying it's best to ensure all licensees and owners agree, including exclusive licensees, is that most licensee contracts won't yet have anything in them about who has the authority to take actions at the UPC. It may be interpreted that taking an action at the UPC, such as opting out, is seen as a litigation action, which maybe in a contract might be interpreted, if it's an exclusive licensee contract, as only the licensee has the authority to do that, or maybe only the patentee has the authority to do that. So it is really complicated, and probably isn't going to be properly addressed in existing contracts because it hasn't existed up to this point. So the practical thing to do is review all of your licensee agreements just to see what they might say on it. But if you think you want to opt out, make sure that everyone involved agrees. Also, if it's a jointly owned patent and not everyone has agreed to the opt-out, then it might be an invalid opt-out, which means you might get pinned in a different court. I think that's all to say about that.
Okay.
Yeah.
So we're going to talk.
Sorry, I've just seen a question. Mary has asked, is she correct in that no action can be taken by a third party during the sunrise period? So that's the safe period to opt out. Exactly. There's no danger in that 3 months of someone bringing an action at the UPC because the UPC doesn't exist yet. So if you know you want to opt out, that is the time you can do it safely without any risk. And as from day one of the new system coming into force, there's always going to be that slight risk.
There's another quick question in the Q&A, and that is, how do you actually opt in or opt out? Is it just a filing with the UPC?
Yeah, it is. It's a filing on a UP website. We've seen some like beta versions of it, and it doesn't look particularly user friendly at the moment. But yeah, it will just be that. There is the option to bulk opt out as well. As kind of, hopefully it's going to slightly improve before. Because it looks like not very user friendly. But yeah, it is just registering it at this new UP website.
Great, thanks.
Cool. So let's talk about should we opt out, and then we'll whiz through some case studies. And Jeff, when we go through the case studies, so I guess you're aware of how many questions we may have. If we want to skip some of those case studies, you can let us know.
I think we should go through those because they're very interesting, and we can hold the questions for the end. Okay.
So should you opt out? I guess I mean my take on this is that keeping your currently granted normal EP patents, i.e. your traditional patents, your bundle of patents, the non-UP patents, if you like, keeping them in the jurisdiction of the UPC is a risk because the UPC is a question mark, it's untested, it's a blank slate on case law, etc. So I personally, this is my personal opinion, I think a useful default for lots of companies will be to opt out their existing patents as standard and opt out future patents, assuming they don't want to file or obtain unitary patents. I think that's especially true if patent families are particularly valuable. So if you've got, crown jewel patents, as a company, I would be thinking about opting those crown jewel, extremely valuable patents outside of the jurisdiction of the UPC because of the risk of, for example, central revocation. And so my approach to when I'm advising my clients is coming at it from that angle of, well, it's a risk. Let's assume that a useful default is to opt out. Are there reasons why you should opt in? And of course there are. If you expect to be litigating across Europe in lots of different European countries, if you're attracted by this idea of like simplified European litigation and a pan-European injunction will be extremely useful for you as a company, then perhaps you'd want to opt in some of your patents so that you can make use of that system. So hopefully that makes sense. So let's move on with the case studies, which I think are particularly useful. And everyone feel free to jump in with comments because I think it's worth saying there's not really any right or wrong answer when it comes to what should these companies do. So let's start with this fictional company. So they've got multiple low value products, each covered by 1, 2, 3 patents. At the moment, using the current system, they typically validate in a handful of EPC states, 3, 4, 5 EPC states. That includes the UK, France, and Germany. And this company have had some bad experience when it comes to French litigation. They don't like the way the case law is built up in France, for example. So how to get a toehold onto thinking about what this company should do when it comes to unitary patents and the UPC? I think a useful starting point is, well, take a look at the current validation strategy. Would this company save money by swapping to start obtaining unitary patents instead? And you'll remember that we said that renewal fees are based on filing in around 5 member states. So the combined cost of renewal fees, the cost of renewal fees for unitary patent are roughly equivalent to 5 member states. So actually, this company wouldn't save money if they were to swap to obtain unitary patents instead. They'd have to increase their budget to do that. And judging from their validation states, it looks like the UK is of interest. That's a good market for them. And so if they were to obtain unitary patents and they wanted to still get protection in the UK, they would have to additionally separately validate things. So potentially the budget would massively increase or increase significantly. So I'll probably be saying to this company to continue validating as usual. And as for should they opt out their existing portfolio and their future traditional European patents, well, it's a big risk. There's a question mark coming from, and this is my view, coming from the default of let's opt out. Are there reasons to opt in? Well, actually there are. This company doesn't like the way that French litigation has treated them in the past, and so perhaps they would like the option of taking actions in the UPC instead. But for me, my advice, and this is on the slides, which you guys will have access to, I'll be saying to this company, you won't be saving money by obtaining unitary patents, so don't. And opt out all of your cases because I don't think this aversion to French litigation outweighs the big risk of the UPC. That all make sense, everyone? You guys happy with that?
Yeah, that does. It is all worth noting the kind of points of balance that.
Just a quick question, Tom. Should your subject matter of the patent come into play as you're in your example, you had a bad experience with French litigation. If you have a patent that would wind up in the central division in France based on subject matter, should that be something you bring into your decision making?
I guess so. Yeah, I mean, it depends on it. I guess this is a very general point, isn't it? It depends on the nature of why they don't like French litigation.
Yeah.
Yeah, I think that's probably a good point. Cool. Okay, so with switching these, I'm aware of.
Yeah, sorry. One thing I was going to say, Tom. It's worth saying for balance, kind of the clients that Tom and I work with, we kind of maybe on the side of saying opt out unless you have a really good reason to opt in. I have a colleague who is one of the reasons being that the UPC is a big unknown and we have no idea where it's going to go. A colleague is of the opinion that it's a big unknown, we have no idea where we're going to go, so we might as well get in and be part of steering the direction of those courts. So it is a risk, but one potential positive is that you kind of are involved in steering that if you're thinking, well, it's going to come for me anyway. So it's just, it's so nuanced. It's really hard.
Yeah, there are certainly no right or wrong answers potentially. So let's go this second fictional company, electronic apparatus portfolio, diverse portfolio with a handful of patents covering each aspect of a broader system. It's fast moving, so products are going to be obsolete within 3-4 years. They typically validate in only the UK, France, and Germany, but they do have, occasional interest in other places as well due to competitor activity. So again, I usually start with, would this company save money by swapping to obtain unitary patents instead? Well, they only validate in the UK, France, and Germany at the moment. So it's the same consideration as before. So this company probably wouldn't save money by swapping to obtain unitary patents. Are there reasons to obtain unitary patents anyway? Well, potentially, there's some competitor activity there in EPC, UPC states. So they might want to file unitary patents to widen their, economic and the geographical scope of their protection. Should they opt out? Well, I guess the question is there anything which justifies, this is my, again, it's how I approach it, is there anything that justifies the risk of entering these existing patents into the untested, unpredictable new court system? Again, possibly there's this interest because there's competitor activity. It's worth saying that this company probably won't have to think about the maths of, well, the unitary patent renewal fees after 10 years increase significantly because they're probably not going to be keeping their patents enforced for that long. So I would be saying to this company, do opt out your existing cases. And maybe do a mix of unitary patents and continuing to file using the current system, because you might want to obtain some unitary patents in view of this competitor activity. So something to bear in mind in the future. Maybe doing some sort of an intelligent mix and don't put all your eggs in one basket. Cool. So how about this one? A high value pharmaceutical portfolio. One main product patent on an original chemical entity that's validated in all EPC states. There's numerous follow-on cases relating to dosages, formulations. Some of those are granted, some are pending. And this company, as you would expect, are worried about generic competition from imports. So that patent family, that original chemical entity patent at point 1 there is going to be extremely valuable. That's what I think about when people talk about, crown jewel patents. So let's think about this. Would this company save money by swapping to obtain unitary patents? Well, almost certainly yes, they validate everywhere. So swapping to obtain unitary patents is going to be not only much simpler, but also probably quite a big cost saver. But should they do that? Should they opt out? Should they opt out? So I would be saying to this company, you would save money by filing unitary patents, obtaining unitary patents. But if you do that, you're opting into this new court system, which is risky. I would be saying opt out that extremely valuable patent family at number 1 to remove that from the risk of central revocation. But some of these potentially less valuable dosages and formulations, maybe the risk, the cost benefit analysis for some of these is different. Maybe you should obtain unitary patents so that you benefit from the cost saving, this huge cost saving, despite the potentially increased risk. And actually, some of the features of the new court, for example, being able to get a centralized decision, could be very useful against this generic competition from imports. So I would be saying, let's see if what I'm saying now agrees with what I wrote before. I would be saying, do opt out that extremely high valuable case, at least, and consider filing unitary patents in the future to benefit from the cost saving and to get some protection at a centralized court system for some of this generic competition. So shall we skip forward? You'll have this case study on your slides that we sent out. Jeff, Paul, let me know if you disagree with that. And should we skip forward to this timeline, Emily?
Yeah, thanks. So we wanted to kind of finish. There have been loads of great questions. So please do, feel free to contact Jeff or Paul or Tom or myself or anyone so we can try and wrap up on any of those questions. But we thought it'd be good to finish with the kind of next practical steps that we as practitioners or maybe as patent owners can take. So this is the timeline for when we expect things might happen. So the far right there, you've got October 2022. That's probably the earliest it's going to be. So they're currently kind of trying to as Tom said, recruit judges, get the IT systems in place, find physical locations, sort out all the rules. So there's quite a lot for them to do. So 1st of October is probably the earliest it's going to be. It might delay by a few months. That's the start of it. 3 months before that is the start of this sunrise period where you can do 3 things. You can opt out of the UPC, as we mentioned, in that safe zone with no risks. And you can also make use of those mechanisms to get your granted patents into unitary effect, deferring them or filing an early request. On the right, on the far left-hand side, is what we can be doing now, which Tom is going to cover in this final slide.
Cool. So this is a summary. Granted EP cases, these are your traditionally granted European patents, which are already granted. Decide which of those you want to opt out from the jurisdiction of the UPC. Prepare a big schedule, contact your attorneys to make that happen, because they'll want to start doing things soon. For your pending EPO applications, not granted yet, currently undergoing prosecution, prepare a schedule of those which you want to opt out. And also, if any of those you already know that a unitary patent might be of interest, flag those in a big schedule, because you might want to start delaying prosecution on those cases to buy time for the new system to come in. The third one, which sounds obvious, but factor the UP and the UPC costs and risks into future filing strategies. If you need to communicate internally to stakeholders or to your clients about these changing risks, changing costs, then start thinking about doing that now. And as Emily was saying, that this idea of making sure that your opt-out is making sure that your opt-out is done correctly is going to be really important. If you are going to be opting out when filing that request, you'll need to confirm that you have the authority to opt out of the patent. And so starting that conversation, if there's a license agreement, if there's co-owners, multiple owners of the same patent, you'll need to have that conversation about who has the authority. And doing that now is the best time to do it, because you're only going to have 3 months from when Germany ratifies things. So yeah, thanks very much for listening to us, for attending the webinar. These are the speakers from Kilburn and Strode. These are the speakers from Schwegman, and thank you so much, Paul and Jeff, for your partnering with us on this. We've really appreciated it.
Yeah,
Thank you.
we love working with Schwegman, so it's great to partner with you.
Yeah, you guys are really up on this.
Yeah.
Thank you. Thank you everyone for joining us, and thank you to our speakers, Emily Collins and Tom Hamer. We invite you to join us for future SLW Institute webinars. This Thursday, March 24th, the SLW Institute is presenting a webinar about recent developments in China in IP. For more information and to register, please visit the SLW Institute on the Schwegman, Lundberg, and Worcester website. Take care, everyone, and we hope to see you back soon.